Hello, my name is Michael Kaplan. I am a CPA, CVA, and CFFA. I am a forensic CPA, and I've been practicing in the world of financial forensics for more than 36 years. I am principal of Kaplan Forensics in Los Angeles. I am also president of the Financial Forensics Institute of the NACVA and principal of the American Institute for Expert Witness Education. I also offer consulting services and expert testimony through expertmentoring.com. I'm here today to share some of my perspectives relating to giving expert testimony in business valuation matters. This is the Business Valuation and Litigation QuickTip. One of the issues that I've encountered as an expert is that the calculation engagement, the calculation of value process is one that is often given less attention by valuation experts than it really should be. I believe it's a very powerful tool if used right. I think it's a very powerful tool if it's used in the proper setting, and it can be a very dangerous tool if it's used outside of the proper set of circumstances. About a year ago, at an expert witness boot camp that we were presenting through the NACVA, we had an attendee who provided us with an expert report that she was using as a subject of her testimony in the program. And it was a valuation report, and it was a report in which she presented a calculation of value in the context of a family law, a matrimonial matter. She was testifying on behalf of the wife in the divorce, and her client had very limited funds, and because of the limited funds, she chose to perform the engagement as a calculation at a much lower cost than performing the valuation as a conclusion of value engagement, which would carry a significant cost with it. This attendee gave very, very good deposition testimony. She was very experienced, but had not yet experienced taking the valuation into the courtroom in the form of a calculation. I had the privilege of cross-examining her in the trial. She gave exemplary direct examination, but when I began to cross-examine her, I quickly got her to admit that the conclusion that she set forth, or that her opinion of the calculation, was less reliable. There was more play in it. It was less founded. The analysis was much less in depth than it would be had she done a conclusion of value. The reality is she would have not survived the light of day. She would not have survived the rigors of the courtroom if she had taken that into a real trial. That is an example of using a calculation of value in the wrong circumstances. About 4 years ago, actually about 3 years ago, I was brought into a lawsuit as an expert. I was asked to perform a valuation of the business. I looked at the books and records. I looked at the documents that were made available through the discovery process, and I provided my retaining counsel with a list of the documents that I wanted to see: financial statements, tax returns, general ledgers, supporting schedules, contracts, the customary information that we would want to see. Unfortunately, it wasn't available. No matter what he did in discovery, opposing counsel resisted his efforts to get those documents. We also found that through the discovery process, we did get some documents that were conflicting, that indicated that there were two sets of books. I sat down with my retaining counsel and I said, there's no way for me to formulate a conclusion of value with the evidence that's available. There's just too much that I would need that has just not been produced. What I did was I shared with him that I could perform a calculation of value, that if I would go into the courtroom, explain to the judge, and it was a bench trial, that this was a calculation of value and that I was just precluded from having access to that evidence that I needed, that foundational evidence that I needed in order to formulate a conclusion of value, and that the only thing that could be done was a calculation. As it turned out, that's what I did, told my story in the courtroom. The opposing expert, the defendant's expert, took the witness stand, and he took the position that there was no problem performing a calculation of value. He offered his opinion, no problem performing a conclusion of value. He offered his opinion, and he stood by his opinion. He claimed that it was well-founded. But in rebuttal, I was able to demonstrate that what he had done certainly didn't meet the professional standard of any of the valuation credentialing organizations, not of the NACVA, not of the IBA, not of the AICPA, that there was no way that what he did could have met the professional standard given what he had available. I soon realized that this stepchild of the industry, the calculation engagement, is one that could be very, 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 very powerful. I know that valuation experts try to stay away from calculation engagements because we are so programmed and so trained to be as in-depth, as thorough as we can, that we need to do the appropriate analysis, and we feel very uncomfortable when we start replacing that analysis with assumptions. We feel uncomfortable when we don't do the foundational research. And usually we're asked to do a calculation engagement because the client just doesn't want to spend the money, or the law firm doesn't want to spend the money and does not see the value in having the valuation engagement completed. There's also a risk that many of us as valuation experts recognize in performing a calculation, and that is that the clients often don't understand that it's a different product and that there's a different level of reliability in that product, and it's easily perceived as being a full-blown conclusion of value. So we typically stay away from those. I mean, that's just our nature. That's typically how we have been trained as valuation experts. But in litigation engagements, we must recognize that everything has to be built upon the evidence. And wherever there are holes in the building blocks of evidence, when we don't have financial statements, when we don't have the underlying research, when we don't have the contracts that we need to look at, or other important pieces of evidence, opposing counsel will attempt to discredit us when we're on the witness stand. So what we need to do in those situations where it is clearly impossible for us to get what we need, where there's clearly a limitation on the foundational evidence that we have, we're not getting the books and records, we need to recognize that that is a great, great opportunity to offer a calculation of value in lieu of the formulation of a conclusion of value. But just remember, we do it only when it's impossible to get the documents, impossible to complete a conclusion assignment. We do it only when not having some sort of expert opinion will put the client, put the law firm at a clear disadvantage when there's going to be another expert who's coming in and offering what he or she represents to be a conclusion of value, when usually it is not. But one time that it is never okay to substitute a calculation of value for a valuation engagement leading to a conclusion is when the parties want to save money. That's not a good reason. That reason will backfire in the expert's face. I can guarantee it. Just remember, if you're going to do a calculation, if the circumstances call for it, the evidence isn't there, if the foundation isn't there, remember that you as an expert must define the methodology, the appropriate methodology. You as an expert must define the assumptions that are going to be relied upon. and the manner in which the project is going to be approached. Don't let the client do it. Don't let the law firm do it. Because then what it does is it looks much like an agreed-upon procedures engagement in the accounting context, where you as an expert have done just what your client has told you or what the attorney has told you. So the way we present it, the way we present our calculation is that we as experts defined the work to be done based upon our SKEET, S-K-E-E-T, our skill, our knowledge, our experience, our education and training, right out of Rule 702 of the Federal Rules of Evidence. And that once we have defined those and we have selected them, we represent that given what we know and our understanding of the case, that those are the best assumptions, the most reasonable assumptions, the appropriate methodology, the appropriate procedures that would be used if we were to perform a valuation engagement leading to a conclusion, but we can only formulate a calculation of value. But we define it. We also have to be clear when we're sitting on the witness stand that a calculation engagement does meet the professional standard of care. That yes, it's a scaled down service leading to a much narrower product, a much narrower opinion, but that yes, it meets the standard of care. Usually the calculation of value is offered when the expert on the other side takes the witness stand and is representing that what he or she has a conclusion of value. Under those circumstances, it's incumbent upon us as the expert to demonstrate why, to dissect the other guy's report, to dissect the other guy's opinions, and demonstrate that they don't meet the professional standard of care. We need to use our maintenance of the professional standards, our embracing of the professional standards, to support why we performed a calculation engagement and to support why the representation that the other expert made is likely not to be a conclusion that meets the professional standard. The thing to remember is that a calculation of value, although it has more limited application, could be a very, very effective, a very, very powerful tool to use in litigation engagements under the right circumstances. But you have to evaluate the circumstances of the case. You have to step back and ask yourself, does it meet the criteria? Is this the appropriate situation? Can I use it effectively? Or am I just shortcutting and will it backfire on me? Ask those questions. If you're involved in an engagement and you have many questions as to whether or not a calculation engagement is appropriate, if you're involved in a litigation matter, for that matter, if you have any questions and you want to bounce your questions off of someone, you may want to give me a call. Feel free to call me. My phone number is area code 818-888-0066. My email is michael@kaplanforensics.com. If you are interested in mentoring services, feel free to reach me at expertmentoring.com. And if you want to become more involved in the programs that are offered through NACVA, through the American Institute for Expert Witness Education, feel free to enroll in the Expert Witness Bootcamp, the Level 1 Bootcamp, the Level 2 Bootcamp, or the various other workshops that we have to enhance your skill in the area of witnessing and delivering your valuation opinions in the courtroom. It has been a pleasure to be here today. Thank you very much for attending.